Hello, everybody. My name is Candida Steel, and I'm retired as a judge on the U.S. Civilian Board of Contract Appeals. I've been able to travel around the country as a result. And I've been working with this program for nearly 20 years, so it's a pleasure to see all of you. Ben, if you'd like to introduce yourself.
Oh, sure. My name is Ben Glickman. I am a supervising deputy attorney general with the state of California. Much more interestingly and importantly, I'm an alumnus of this fine program and was lucky enough to be on a national championship team some 25 years ago. We didn't have Zoom. We did have the internet, just barely.
I'm Marcia Holland. I was a career public defender in Alaska, but since moving to Montana, I now teach at the law school here in Missoula. And I too have been involved with this program for about the same number of years as my two fellow judges. So I'm so happy that you're participating this year.
Me too. And if you'd introduce yourselves, please.
Good afternoon. My name is Shelby Ellis, and the woman who is most inspirational to me is Mary Church Terrell for being one of the first African-American women to graduate with a college degree.
Hello, my name is Elizabeth St. John, and the woman who is most inspirational to me is Ruth Bader Ginsburg for her efforts towards ensuring gender equality.
Hello, my name is Calvin O'Connell, and the woman most inspirational to me is Serena Williams for defying gender norms and promoting the importance of Title IX.
Hello, my name is Janaya Ishong, and the woman most inspirational to me is Alice Paul for being an iron-jawed angel and fighting for the ratification of the 19th Amendment. On behalf of Tahoma High School, our advisor Gretchen Wolfing, and the state of Washington, we thank you for judging today.
Great, thank you. And I'll read the question for the record. We're Unit 3, and I think it's question number 3. In 2020, we celebrate the ratification of the 19th Amendment, which recognized the right of women to vote. Despite recent controversy, the Equal Rights Amendment has not yet been declared ratified. What are the similarities and differences between the two amendments? What impact, if any, has the 19th Amendment had on women in achieving equality with men in the United States and around the world? What are the advantages and disadvantages of states passing their own equal rights amendments rather than ratifying a national constitutional amendment? You may begin.
Men and women are persons of equal dignity and should count equally before the law. Ruth Bader Ginsburg.
The 19th Amendment and the Equal Rights Amendment are similar in their expansion of rights for women, but differ in their legislative intent.
The road to women's suffrage lasted over a century, culminating in the ratification of the 19th Amendment in 1920. This established that voting could not be denied on account of sex.
The right to vote was later upheld in Lesser v. Garnett, in which a Maryland statute barring women from voting was overturned.
In comparison, the Equal Rights Amendment continues to promote greater equality outside of the realm of suffrage.
The ERA was first proposed in 1923 by the National Woman's Party, and as of January 2020, has been ratified by 38 states.
Section 1 holds that the equality of rights shall not be denied on account of sex, shielding against injustices not covered under the 19th Amendment, such as pregnancy discrimination, equal legal rights, and inequitable pay.
However, while gender bias is deemed illegal in 100 countries, this key safeguard is non-existent in our own Constitution, necessitating the ratification of the ERA.
Ultimately, the 19th Amendment was a catalyst for constitutional gender equality, but more must be done to achieve true equality between men and women.
At its passing, the 19th Amendment gave women an increase in political influence, but failed to achieve true equality between the sexes.
The 19th Amendment enfranchised 26 million women and was a product of the revolutionary belief that men and women have an equal status in a democracy. However, despite this success, it still failed to dismantle women's treatment as second-class citizens.
With the decision of Craig v. Boren, the Supreme Court established intermediate scrutiny, whose sole purpose is to discriminate based on sex. As the University of Pennsylvania Law Review explains, this approach meant that gender would be treated as a sensitive classification, but was not severe enough to warrant strict scrutiny, thus perpetuating inequality.
Moreover, women today still lack equal pay, with women making only 85 cents for every $1 made by men, according to a 2018 study conducted by the Pew Research Center.
Furthermore, the 19th Amendment had no impact globally, as 15 other countries had already granted women suffrage before the United States.
While the 19th Amendment granted women the right to vote, it did not fully label men and women as equals, with its influence staying confined to America's borders.
Several complexities are associated with the state's ability to ratify their own equal rights amendments.
While the enactment of a national ERA remains elusive, 24 states have included provisions in their constitutions addressing gender equality, enabled through federalism established in the 10th Amendment.
By allowing states to ratify their own amendments, they function as laboratories of democracy in the pursuit of gender equality.
In the Washington State Supreme Court case, Darren v. Gold, a regulation prohibiting girls from participating on the boys' football team was overturned, as it infringed upon Washington's Gender Equality Amendment, established in Article 31 of the state constitution.
However, this expansion of equality is constrained only to states with an ERA, posing discrepancies of gender equality nationwide.
Moreover, the necessity of a national ERA has come into question through Title VII of the Civil Rights Act of 1964, which bars race and gender discrimination in the workforce, as well as Section 1 of the 14th Amendment. There are already safeguards in place to promote equal opportunity.
Rather than undergoing the amendment process explained in Article 5 of the Constitution, the government can reinforce the provisions already in place.
Overall, a federal amendment that establishes gender equality could provide the protections that many desire, while state amendments could implement highly progressive versions that better protect the nation.
Regardless, there is no disadvantage to firmly establishing equality between the sexes.
Thank you very much. Do you want to start, Marcia?
Yes, I was just unmuting myself. So I want to follow up on the last point you were making. Historically, there were 15 states, primarily in the West, that had granted women the right to vote before the 19th Amendment was passed. And as you indicated, there are a number of states, I think it was 24, that have passed some version of the Equal Rights Amendment now. But the language in those 24 states in that, that protection differs wildly. So don't you think, I know that you said that you think a national ERA would be better, but do you think the one that's written now is the best version of how an equal rights amendment should look?
I strongly believe that while it is important to pass a national equal rights amendment, the writing in the equal rights amendment passed by most states is not enough to provide the protections that we need. We can see that in the most progressive state provisions for gender equality, such as Article 2, Section 18 of New Mexico's state constitution. They provide not only a guarantee for gender equality and a guarantee against discrimination based on sex, but they also provide guarantees for a ban on discrimination based on sexuality and a ban on transgender discrimination.
And by having a national ERA, it would set a bar that states could not go below, as in the state of Louisiana, Article 1, Section 3 of the Constitution states that no law may unreasonably discriminate against any person on the basis of sex. And there's no exact definition as to what law would be unreasonable, but by having a national ERA, it would set that no law can discriminate against any person on the basis of sex.
And in addition to your point about should it be passed as it is on the federal level, I would argue that it shouldn't be passed with its current wording. Right now, the wording in Section 1 uses the word sex, but I think that it should be changed to gender. And this is because under the 14th Amendment Equal Protection Clause in Section 1, we can see that all persons, persons meaning everyone, no matter how you identify yourself, should have equal protection under the law. So I think that to be more able to fully embrace equal opportunity and equality under the law, that word should be changed to gender.
Thank you.
Thank you.
The 19th Amendment uses similar language, right, on account of sex. So would you say that we need to change the 19th Amendment, or has the 19th Amendment's failure to specify gender resulted in discrimination in some way that needs to be remedied?
I don't believe that the 19th Amendment and its vagueness in terms of sex versus gender has resulted in as much discrimination as other things have, such as black codes and discriminatory practices in the South. This is why we can see that despite the 19th Amendment's passing, which supposedly enfranchised 26 million women, we still saw a large portion of that population being women of color and minority women still fought disenfranchisement in the South.
Moving to continue off my colleague Calvin's point, we can see that even if the 19th Amendment didn't exactly give women the equal voting rights that they needed, or other groups, we can see that this was fixed with the Voting Rights Act of 1965. And I do think it's important to recognize what my colleague Calvin did bring up, is the fact that the 19th Amendment really only enfranchised the white women of the nation. And lots of states, particularly in the South and on the East Coast, were majority colored women, especially an example would be South Carolina, where over half of the population was African American.
And building on my colleague Calvin's idea, there is still disenfranchisement occurring in the United States today. We can see this with stringent voter ID laws, which take place in North Dakota and infringe upon our substantive right to vote, which was established in Virginia State Board of Elections v. Harper, and that Native Americans are no longer allowed to exercise a substantive right due to the stringency of these laws.
Thank you. If I can ask a new question. You all mentioned that Virginia became the 38th state to pass the ERA on January 15th, 2020. Should the archivist register this new amendment?
In February 2019, Ruth Bader Ginsburg argued that we should restart the amendment process, as there's too much controversy surrounding trying to revive the amendment that was passed in 1972.
I'm going to disagree with my colleague Elizabeth. I do think that the amendment should be added to our federal constitution. We can see that states have tried to rescind support through amendments beforehand. So in the 14th Amendment, Ohio and New York rescinded support. In the 19th Amendment, Tennessee rescinded support. However, despite this attempts to try to stop this amendment from being ratified, it still became part of our federal constitution and helped achieve greater equality today.
I'm going to have to agree with my colleague Janaya. I think that with the existence of our current constitution in its current state, with the 14th Amendment, we can see that not having an ERA is contradictory to the 14th Amendment, because we can see that we're not guaranteed equal protection under the law without the ERA. And so I think,
Go ahead.
And so I think that it is a necessity in order for us to create the America that our founding fathers wanted to, as stated in the Declaration of the Independence, all men are created equal. And I think that we need to pass this ERA in order to make that vision happen.
Thank you. Thank you. What a great job. Fantastic. So Marcia, do you want to start?
Sure. So I am blown away at the depth of your answers to my question. The first question I had the opportunity to ask, it was thorough. It hit on everything I had been thinking about with this particular, question. I mean, the general question that you were given, especially the second subsection. And if I got to be a question hog and ask a follow-up, but we have limited time, I would have asked you about section 2. Because section 2 is also something that really was a big hang up for some of the women who were not supporting the Equal Rights Amendment. But deferring to my other judges, we got a more robust question and answer period, but I know you would have had great answers to that question too. So thank you so much. I really appreciate it.
Yeah, I would agree. Very well done. You're very well prepared, and I thought the prepared remarks did a very nice job of walking through all parts of the question in a clear way where it was easy for me to follow, which is always appreciated. You had lots of good supporting evidence in the Q&A. Examples from other states, cases where appropriate, historical references, and so that's all to be commended. If I had any constructive criticism, I just really encourage you to listen very closely to the question and make sure that you're responding directly to it, and not answering the question you might have wished was asked. I know it's easy to hear something a little bit different than what was actually asked. So just be sure you're listening very closely to the question. And I'm just really thrilled you guys are here and that you were able to get a few more weeks with Miss Wolfing. She's one of the best. So congratulations.
Great. I agree. I think you did a really lovely, lovely job. You you were, somebody, I heard somebody say once in a hearing that they were very impressed because you gave a beautiful summary, and I'm just repeating what they said. You gave a really beautiful summary of the issues that we need to look at today. But in response to each of our questions, you showed a really impressive depth of understanding and subtlety about each of the questions we were asking that I thought you did a really beautiful job of showing us how much you had experienced and how much you had learned in the process here. So what I really hope is that you use this experience that you've had, that it's bitten you, that you're inspired in some way. I mean, you might end up being doctors or, I don't know, road builders or something, but I hope that this has inspired someone or more of you to use this experience to become lawyers and judges and representatives and senators. And I have to say that you know way more about the Constitution than my law school Constitution class knew when I was in law school, and perhaps more than Marcia's students know now. So I would be very happy and comfortable to be sitting in my rocking chair, and I'll say in assisted living, not in a nursing home, please, at the moment, but that you all will do really well and represent us in the next generation. I'll be sleeping much more easily. Thank you very much. You did a really sterling job.